Happy Friday, everybody, and welcome to another episode of Legal Tech Week. It is the last day of July 2026, and this is the show where we talk about the top stories happening in legal tech and legal innovation. And I am Bob Ambrogi. I write a blog called Law Sites and have a podcast called Law Next. And our other panelists today are Stephanie, you want to kick it off?
Sure. Hi, everyone. I am Stephanie Wilkins. I am the Director of Content at Legal Tech Hub. Hopefully, I'm with you the whole time. My laptop died today, and I have an appointment right after this I have to run to. But yeah, we're trying. I have this whole setup with like a wireless keyboard swag and an iPad and everything. So hopefully, I stay with you for the whole hour.
We hope so, yeah.
Yes.
All right, Niki.
My name's Niki Black. I'm the Principal Legal Insight Strategist at 8 a.m., the team behind My Case, Law Pay, Case Superior, and Docket Wise. I write legal tech columns for ABA Journal, Above the Law, and the Daily Record, and looking forward to being here.
And our resident wine expert. It's like the more I see you so much on social media now giving your wine advice that I almost forget you write about tech too.
Yeah, I have two passions right now, I guess, wine and tech. They don't overlap much, but I try.
Oh, I think wine and tech should overlap all the time.
Yeah.
Speaking of ILTA, anyway, and also Rhys.
Sure. Hi, I'm Rhys. I'm the editor-in-chief of Legal Tech News.
All right, and Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. And for the next month or so, I'm I'm a constantly returning guest every couple of weeks on the Legal AF podcast on Wednesdays. And then I'm your wine expert, but because I complain about things, I guess. So that's my. Oh, I was gonna. Oh, hey, have we talked about this one yet? I went and saw that movie. The Legora commercial guy did. It was really good.
What?
Or are you
Jude
tracking?
Law?
Are you the guy who shot the Legora commercial with Jude Law was the guy who did the Odyssey. He's the cinematographer for Christopher
Oh,
Nolan, which he'd done several movies for Christopher Nolan before, including and then now this one. But I just like bringing that up because it's the most absurd little fact that I know is that they decided to invest in that guy to shoot their little commercial rather than get, me with a camcorder or something, which would have been just as well.
Camcorder's a real throwback.
Yeah, well, there.
My wife was
mean,
complaining
vintage.
last night about how that commercial haunts her. She's like, can't get it out of her mind. She hates it so much. And she doesn't understand why in the world any company would have done something like that.
I mean,
So I don't know whether that's the
effective.
reception overall or what.
I don't know if that means it's effective or not. Like if you can't get it out of your head,
Maybe.
Can't
get it out of her head, that-
all the time.
I guess she's like haunted by images of Legora. We're talking about Legora, Andrew. Legora's Jude Law commercial. But I haven't seen the Odyssey yet.
No, I mean, spoiler, they make it home.
I do want to see the Odyssey. Yeah.
There was an article in the Globe this morning about whether you need to see it in full, whatever, 72, what is it, 72 millimeters, 70, whatever they call it, the full glory, or whether you can just see it in any old movie theater. And the Globe critic was like, just see it in any old movie theater. It doesn't really matter.
It's just too hard to get the 70 millimeters.
Yeah.
Like those tickets are almost impossible to get.
Yeah, and it's
The
like only
fun
one
one-
theater in the Boston area. But
Yeah, the fun one that people do is the 4DX one, which is the one where it like shoots water at you during the storm scenes and everything. Apparently that's
Is that
the
real?
version. Yeah,
Yeah.
oh yeah. That the Union Square Theater does that one, has a theater of
I
that
don't
one.
need
Yeah.
random stuff being squirted at me in Union Square Theater. That just is not, no.
sounds like Universal Studios do stuff like that. So I'm still thinking about, even before we get to legal tech stuff, well, I guess we haven't gotten to legal tech stuff, but Nikki, you just sent out this thing about the PR bots, and now there's like this article about this one agency that's now using completely made up people to cram journalists' inboxes with story pitches. And other than Jude Law, that's like also one of my worst nightmares, I think. So
All right. I just noticed that before this started, so I popped it into our Slack, but talk about PDOOM material. It's definitely like nightmare category stuff.
I mean, as it is, I'm at the point of just like throwing my hands up in the air. And when I look at my inbox every morning,
Seriously.
it's like the one thing is anybody using the Gmail like AI inbox thing? It's kind of cool. It tells you all the stuff you should have done or responded to in your inbox. It goes through your inbox every morning and tells you you should have responded to this, or somebody's waiting for an answer.
I'm on Microsoft for work, which is not making me happy. So I miss the days of being on Gmail for work.
Yeah, Gmail was awesome, and I regret saying all those horrible things about Gmail now that I'm on Microsoft 365.
Well, all right. Well, we can talk about legal tech. Nikki, you had a good piece on Above the Law this week about AI evidence and how that's, I mean, we all know that's a growing problem, but you kind of dove into it a little bit. You want to talk about that?
I just popped both links into the chat, the PR art of the AI publicist and then the Above the Law. So my Above the Law column, I focused on sort of the growing phenomenon of fake evidence in cases where the evidence is AI generated, which is, predictable. I feel like we all saw this coming, and I don't think you have to be a genius to see it coming, right? Like that's, people have been using technology to create fake evidence ever since technology has been around. And they created fake evidence before technology, fake signatures, like this happens. But AI makes it really easy to do at scale, and it's really does it a really good job at it. So it's popping up in cases, and I talk about two of them in my article. And it's making the judges really angry. They're imposing jail sentences. They're not just going for like regular old civil sanctions. They're getting pretty mad, and I get it. Both judges use pretty heady language about the integrity of the justice system and how it undermines it, and they're right. But what I found interesting more than that was an overarching trend. When AI first came out, I talked about this, and we all did. It wasn't just me by any means. Everyone's talked about it. How AI had the potential to start rapidly blurring fiction and reality. And I think that when it comes to the trends that you're seeing in our court system with hallucinated cases, and then the hallucinated cases that are in the briefs end up in orders sometimes, court orders when they're not caught, and then the courts have to amend their orders when they are eventually identified. And so you're seeing this blurring of reality and fiction there, and then you're seeing it with evidence. And on LinkedIn, a judge, his name escapes me, but he called me out. He disagreed with me, and he said that you can't really conflate the two. They're very different things, and I know he's right, But when I look at it through this, and there's very different reasons for them happening, and lawyers have ethics obligations. People that are just creating false evidence don't. I mean, they're not the same thing, but I think it is part of this overarching trend of reality and fiction blurring, and it's happening at scale, and it's happening a lot faster now as AI becomes ubiquitous, and the internet becomes AI slop, and AI starts training on its own content that it's created that's all over the internet. And so I always see the like overarching trend, not just in legal tech, and that's what I'm seeing happening. And it's two different examples in legal tech that are affecting our administration of justice in a pretty negative way.
Yeah.
Can't hear me?
I can hear you. Somebody said they couldn't hear you. You sound loud to me.
You're better now. Initially, you were quieter. Hopefully, it's gotten better. But yeah,
I can check sorry, I would have. If I'd noticed, I would have.
Could you start over?
no, it did. It got better on my end, so I didn't say anything. So maybe I don't know how when that comment came in.
Yeah. Volumes at high. almost there. It was at 92%, now it's at 99 on Zoom itself, and my computer is normal. So
I'm not having any trouble hearing you, so I don't know.
usually I have such a big
That's
mouth,
okay.
people don't ever complain about that, so I consider that a compliment.
To the deep fake evidence stuff, it's interesting because like there seems to be a push to change the federal rules of evidence, and it's going really slow. Like I don't think it's going anywhere actually. There seems to be a consensus that, it's not really a problem. It's, like only a tiny percentage of cases, if even, and people don't think like we really need to change the rules. However, like, there are some folks like Professor Moria Grossman, who are like, it's going to be a large issue, and by the time we can actually change the federal rules of evidence, it'll probably be too late. However, it seems to be showing up way more in state courts at this time, I guess, and like family law stuff as well. And there seems to be a question of like, do the courts have the resources and expertise to, to actually determine if, a deepfake is a deepfake? And, like they've been like handling the problem of like fake evidence for quite some time, although deepfakes require a bit more of a technical expertise.
I mean, one big question here is, I mean, obviously courts have to set rules and courts have to impose sanctions and all of that but are sanctions really going to make any difference? Because probably going forward, a lot of the, there are going to be a lot of self-represented litigants who are the ones using deepfakes. Sure, lawyers will try and do it too, I'm sure, no doubt. But if it's the self-represented litigants, they're not likely to even be aware of the fact that there are sanctions being imposed for doing this or whatever. I mean, we've seen even with the hallucination cases that sanctions, only go so far in terms of stopping some kind of a behavior that needs to be corrected. So I don't know. I really don't know what ultimately gets done about this, except that there needs to be better detection technology, I think, available to courts and other litigants to be able to pick up on this, because it's just going to keep getting better and better, the ability to do this.
I also enjoy the times. Oh, I'm sorry. I also enjoy the times when like folks create deep fake evidence, and it's so obviously faked and it's so horribly done. I think we need those types of deep fakes, just really obvious deep fakes, that are just like almost hilariously faked. And I've seen a few of those cases, and I'm like, it's clearly not real. And God knows what's going through people's minds when they, bring that to court.
Yeah. But I agree that we're going to need better technology because, I mean, I think people fancy themselves very good natural AI detectors, and they are very wrong about this. Like they've convinced themselves of certain tells, or they've just, they don't trust anything anymore, which I get that. But like, yeah, I don't know. I mean, this is not exactly on point, but like, do we all see that LinkedIn is rolling out that report AI slop button? And I'm like, that's just going to be wild and terrible. And so, I mean, I feel like everyone, I don't know, it's just really,
Yeah, that button's called the
we're just bad
select
at
all
this.
button.
What?
It's called the select all button.
Yeah.
Like
That from our wine expert.
Yeah.
I mean,
But no.
yeah, the trouble with LinkedIn is it's hard to detect, it's hard to differentiate the AI slop from the other slop that was already there before AI
Right.
came along. This is off on a slightly different tangent, but the other evidence story in the news this week, I dropped it in our Slack channel for our little group here. But I don't know if anybody read that story in the New York Times about the guy who got convicted on child sexual abuse imagery charges based entirely on his username on Kick. I mean,
Yeah.
from reading the article, it sounded like there's absolutely no other evidence to convict this guy, although they did seize his computer and all that. But it sounded like it was entirely based on his username. And he served an 18-month sentence and then went on probation. And then they discovered that the username of the person who was creating these sexual images had an extra underscore in it that nobody picked up on all of this time. So this guy's username was not even the username that was used to commit these crimes. Like, how bizarre is that?
Yeah, it was a Fus Roda versus a Fus Roda. I'll put basically I'll put in the chat like how the two different ones looked to point out how ridiculous it is.
But like, if we can't even detect that, how are we detecting deep
Yeah.
fakes? Like, we
Yeah.
can't.
Right.
I don't know.
Yeah. So,
I wrote about it in my LinkedIn newsletter too, a little blurb about it, but it's unbelievable that it passed, that so many people looked at it.
Yeah.
You know, and so many different, and this person must have looked at it at some point, the defendant, his attorneys who are trying to disprove his conviction, right? To provide evidence in support of him, along with everybody else that looked at it. It's amazing that probably 100 people, I bet, looked at that and not a single person noticed.
Clearly not a single copy editor.
So since Julie's not here, let's point out this is all Canada. This sort of nonsense wouldn't have happened in America.
Oh yeah, we're so much better over here.
I mean, our impeccable record of always getting the right convictions over here is not like what they've got going on up in maple syrup country.
That's right. It was in Nova Scotia, no less. Which is, so, all right. What else do we have? I have nothing this week. Joe had nothing this week. But fortunately, Stephanie and Rhys had things. Stephanie, you want to talk about zero? It wasn't something you wrote in, but something about zero data retention that you had on Legal Tech Hub.
Yeah, Cheryl Wilson Griffin from our team wrote it, but it also came up last week when I was speaking at the Masters Conference in New York. And yeah, so I mean, it came up in that conference in the context of, everyone disagreeing on the Hepner ruling and the other rulings about privilege and et cetera. And, can people really see our chats and whatever. And so this new stance by Anthropic that, for certain of their like Mythos class models, like which include the Fable models, they are retaining everything that gets put in for 30 days to do like I don't think they call it abuse monitoring like Microsoft calls it, but they're equivalent of whatever we're calling abuse monitoring, right? So they can like check it for safety and they can check it for, just improper content, which coincidentally happens in a lot of, legal cases. Like that's what cases are about. So those topics come up all the time. But so, I mean, the question becomes if people are reviewing these for 30 days and if they get flagged longer, does that change anyone's mind on whether or not your prompts are actually going out to other people? And there's others, I mean, there's confidentiality. It's not just a privilege thing, but the zero data retention is what a lot of people have built their whole AI governance strategy around, this concept that there is this, and it's maybe not that anymore. And, I've always been more pro Hepner. I'm not saying I 100% agree with Hepner, but I am, in the minority that sees some merit in it. But I think this is a really important issue that it gave a lot of people pause in the room last week who otherwise did not have pause on this topic.
I thought it was a super interesting and insightful and timely article, and it was something that I hadn't thought about. The idea that AI data retention policies and all the other back-end policies about what's happening to your data is a moving target. The AI is changing so quickly. They're coming out with different tiers. They're coming out with different products, and they're all controlled by different user agreements. And different promised levels of data management on the back end and data protection on the back end. And that can change, right? Like companies suddenly add a new tier and that can impact the tier below it. I mean, we see that happening all the time with all the different LLMs. So I thought it was super interesting to think of it that way. But then what is the solution? What's a company or a person to do when this changes? I mean, it's almost like you need to have a person or an AI.
Yeah.
Maybe the solution is to have an AI monitoring your AI and an AI, monitoring the evidence submitted in court. We just have to turn
Yeah.
everything over to the AIs. I think that's
Yeah.
what's going here.
Well, one of the points Cheryl made on the like, what's a person to do, and it's not a perfect solution, is that, I mean, so far when we've come thus far, most organizations are thinking about AI governance by approving things on a platform level, right? Like, oh, we've approved Claude, we haven't approved Claude. And maybe it needs to be more like approving things on a model level and not necessarily platform level. And I don't know, that's much logistically much harder. I mean, we have a small organization and our Claude, they slowly turn things on with it or whatever. But like when we're talking to bigger organizations, I mean, that's harder to do, especially as people are swapping in different models all the time. But I mean, it definitely is the case that it's model specific threats being offered now within a single platform and not just the platform. It just gets harder.
So, quick question, like, does any tech provider actually have a zero, retention policy? Like it seems that, like the ephemeral apps even, like have to collect data for a short time, like for legal obligations. And like, do we actually have tech providers and like AI companies who actually just, don't ever retain anything that goes into their platform?
Well, we've had these zero data retention agreements for a long time. Obviously, it has changed with the AI of it all. And so I don't know how closely. I think that's part of the thing here. Everyone's still signing these agreements, and are they actually legitimate? I mean, is that such a thing? Um, yeah, it's a really tough question.
Okay, so stupid follow-up question. And I'm the only one here who isn't a attorney, so excuse me for this. Can they have those like zero retention contracts? Um, like if the FBI or like the NSA or the DOJ is like, like we need info on, like this, like person's data. Can those like zero data retention contracts hold up? The issue is actually huge with the Stored Communication Act and like the trying to recall the term, except the FBI could essentially ask Microsoft to turn over the Outlook data for some of its
Hmm.
users, and like yeah, like they actually didn't have to like like tell their um, customers of it. And like it was a huge issue too because like some of the servers were in like France or like Ireland, and it was a whole like like GDPR issue as well. So like like do those zero data retention contracts actually hold up?
Well, Rhys, I am an attorney, and just hold on for a second while I ask Claude that question, and I'll get right back to you.
um, well, I mean, I guess separate from the contracts, like in theory, if they're promising zero data retention, they're not retaining anything and they wouldn't have anything to turn over to the FBI or whoever asked for it. If
Yeah,
they are retaining things against those agreements, that's a completely different question. That seems like a contractual violation. But I mean, there are always like aside from the ZDRs, there's always certain exceptions for like law enforcement obtaining things as opposed
yeah.
to other outside parties. So I don't know. I think it's just I mean, it's a really good question, but it's also a good question is, as we go forward, is zero data retention even possible here? And It's more so like if people think that is protecting them in these contracts, maybe they need to understand what it means and do a deeper dive. And it's like, yeah, and Michelle put this in the comments. Like, I remember a couple of years ago, Isha and Cassandra wrote that article about the abuse monitoring at
Yeah.
Microsoft.
Yep.
It's the same kind of principle. So that this is
Yeah.
not a new concept. It's just now, I mean, Anthropic doing it across certain classes of models is a pretty big deal.
So Cassandra saw this coming.
Oh, but boom.
Yeah,
Is this because you just watched The Odyssey?
yeah, yeah.
Okay.
I'm gonna keep going with these references. Go for it.
Yeah. No, it's a really interesting issue, and everybody who is so anti like the holding of Hepner in the room last week actually had a moment of pause of like, well, if they're actually retaining stuff, what does that mean? Yeah.
Super interesting too. Like, like, do they have to legally retain some stuff? I don't know. I am, again, no attorney. I can ask Claude though, so I'm halfway there.
Well, that's that whole sort of line of questioning is in a sense an interesting segue to your one of the stories you had this week, Rhys, on the sort of increasing use of open weight AI models and specifically Chinese open weight AI models and what that means for legal tech. I know you didn't write it, Benjamin Joyner wrote the story, but do you want to kind of recap that a little
Yeah,
bit?
sure. Then essentially talked to some folks in the legal tech space around like how these like new Chinese models are going to like change the industry or like impact the tools. And they have actually performed pretty well. Like some say they're close to like what the newest Anthropic models can do. And the huge advantage too is, like they are open weight. So essentially, people can tweak them to increase their accuracy around specific subject areas. And they are perhaps the only like open weight models out there. And then talked to TR and one other source where I cannot remember where he was from. However, like they all said that they expect these like open weight models to be integrated into the legal tech tools. They won't do like the front end, like like stuff like the like heavy analysis. However, for like the back end tasks such as extraction, classification, and review, they're pretty well performing. And also they're pretty cheap too, and they're pretty easy to tweak as well. You know, we asked them too if like firms will kind of be able to play around with these too, and like tweak them for their own use cases as well. And the vendors weren't so sure that the firms would be able to do so. However, we came across, I believe it was on like the Financial Times, an article around Kinsey trying to like tweak these open weight models and create something that really is tailored to them. I assume that it's going to have a huge impact because like people are able to tweak it into customize it too. And also, it's quite cheap. The only thing that could potentially prevent these models from taking off in the legal space here in the States is, like if there are any restrictions that come out of the Trump administration. And the folks at like Anthropic and like OpenAI aren't too pleased. They say that essentially these Chinese models were created with the outputs of their own, models, and that's why there's so much cheaper. However, that does beg the question then of like, why won't OpenAI and Claude kind of do the same as well? So like we are keeping a close eye on like how it's going to change the industry, and potentially change the economy too. We can restrict them here in the States. Like however, if they take off everywhere else, like I don't think that does us any good.
Well, listen, I don't think they're long for this world in the States if the recent news that we're banning foreign-made robot vacuums, like, and I included that in my LinkedIn newsletter this week as well. But it's it's basically foreign-made robots are being banned, and so clearly, like, generative AI is not going to be far behind with this administration. I mean, anything that's made in China, and I'm not going to say it the way that Trump says it, because somehow that feels wrong, but I think that it's not far behind if we're banning Roombas made in China. So
So
it's
I
a sign of
will
the times.
say,
Go ahead.
like I've had two Roombas and they're terrible. So I would totally hope to have like an open way Chinese Roomba. It's got to be an improvement.
Well, as Naveen to point out, we talked about this last week a little bit with the with Claude going rogue, not Claude, but the Anthropic models going rogue, and that it took Hugging Face had to use one of these open weight models in order to track down the how the infiltration had happened, because the general models weren't letting it do that. So.
When I saw the headline about that was just like US to ban, Chinese autonomous robots. I was not picturing Roombas. I was picturing like all those crazy videos of like kickboxing robots and fighting stuff. And I'm like, that's okay. I mean, seems like
No,
a weird priority, but sure.
well, now they have the horned centaur with the chainsaw. You've been tracking that one. That's the new nightmare fuel, and
Wait,
I think that's an American company even, right?
horned centaur with
I saw that
chainsaw. I didn't
headline.
see that.
Yeah,
You gotta
Satyrus.
send it in the
Yeah,
chat. That sounds insane.
That's the new Lagora
yeah,
ad. You haven't seen that?
I wouldn't be
yeah.
surprised.
Jude
This,
Law is
this,
riding the horns. Yeah.
this machine, which is designed to protect, to go, save people from places humans can't get to.
Oh
It's a
wow, they
California
couldn't have
company.
designed
Yeah,
that any other way. Like, but that is
yeah,
terrifying. If I saw that coming at me while I was trying to be saved, I'd have
right.
a heart attack.
Yeah. It's it's a decision. Let's put it that way. It's yeah, the Chinese model situation. I've long thought that they had a better strategy for doing things than the Americans, and part of it is an IP related aspect to it, but another part of it is a lot of our AI culture is based around people with messiah complexes who think that they're going to invent artificial general intelligence, and the Chinese models are like, what if we gave you something cheaper that like fixes your email? And it's like, yeah, that would be great, I would love that. And so I think their strategy, I've long thought that if there's an American version of that strategy, it could end up dominating, because it could be the much cheaper option that gets all the way there without not being able to answer questions about Tiananmen Square.
Um, and that's also super interesting to the timing, just due to the pricing concerns too. Like all those corporations are like freaking out over like, oh, our like costs are so high, and we were supposed to save costs, although our cost on like Claude or ChatGPT are whatever are just through the roof. And
Hmm.
as cost concerns are, growing, these new models are coming out, and I'm like, well, it's like the perfect storm too.
Yeah. I this is completely unrelated, but since we just talked about intellectual property law, one story that came out of this week that's not really a legal tech story, but is a legal story is the Anthropic was getting a lot of flack this week for it came out that they are buying up all the rare books in the world and destroying them, just chopping them up as they
Uh,
scan them. And people were like, "Oh, this is so evil." And now I saw social media where it's like, they have these devices they are able to scan them without damaging the copy. But the reason they're doing that, of course, is that in our the infinite wisdom of our intellectual property law, the court order that they're under is that it's fair use so long as at the end of scanning it, there is not a physical copy that remains. Because the rule was you can transform it from a physical copy to a digital copy, but if you add a new copy, then that is no longer fair use. And so that's why they're doing this, is because the court order that Judge Alsup put in puts them in a situation where they only are allowed to scan these particular rare books if they choose to destroy it at the end, which is the reason they're doing it. So it's yet again, we have a broken intellectual property system, which should be reformed, but no one has the time or energy to do that because our Congress has more important things to do, like relitigate vaccines or whatever the hell they're doing these days.
Yeah.
I did see that RFK has a new cooking show. So
Oh,
speaking of
good.
like vaccines, yeah.
I heard he was pushing that everyone needs to start eating more liver this week, and all I could
Yes.
think was that is, there's a winning strategy. Tell people to eat liver. That has worked for so many generations.
People will vote Democratic just not to do
Yeah,
that. Um,
they've come a long way from H.W. Bush telling them not that we aren't going to have broccoli anymore, and now they've come around and they're like, but yes, liver.
all
The
right.
list
Well,
of things we can and
yeah,
cannot eat currently is growing, so I'll take whatever just is disease free at this point.
yeah. I have children who have a whole litany of food allergies. So the list of things we couldn't eat in our house for a long time has been extensive already. So it's just getting worse. So I didn't write anything this week because I was engaged all week, and as I said to Joe earlier, sort of lobbying Lollapalooza, which is one of my other jobs as a lobbyist. And this was the end of our legislative session here in Massachusetts, and it's been a really crazy week. Except that I'm happy to say I got through something that I've been working 21 years to try and get through the legislature. So it's like kind of crazy that it took that long. But so it's been a very exciting week. But I was thinking, I've been thinking a lot, finding myself thinking a lot about legal research. And there's been a whole lot of developments over the last couple of weeks that I think start to have sort of a common theme. And Describe, I know I saw Richard in the audience from Describe, and they had news this week that I haven't had a chance to write about. I don't know if anybody else did, but they announced this new what do they call it? New open connector, here's what they describe it. I'm reading their press release. A new initiative that enables law firms and legal organizations to build, customize, and control their own AI-powered legal research tools and workflows on top of Describe's legal engine. There's two parts to this. There's an SDK and a Python SDK that provides the technical foundation for connecting custom applications to Describe, and then there is a set of legal research workflows, which are reusable research processes that organizations can use, modify, or expand to reflect their own needs. So that was interesting. But then also, just in the last couple of weeks, last week I talked about this thing wrote about called DingDuff, which is this MCP connector that two lawyers started, partly because they just didn't like didn't like what they were getting out of Westlaw and Lexis, and also partly because they were afraid that Westlaw and Lexis were just going to make themselves so expensive and unaffordable that they wouldn't be able to use them anymore. So they decided to kind of create their own legal research tool connected to MCP that does research kind of the way, lets them do things the way they want to do them. And then there's another new legal research product that's coming out Monday that I don't think it's been formally announced yet, so I won't mention it. But
Yeah, Argo. Yeah.
Yeah, are they out? Yeah. So, but that's again taking a kind of a very distinctive approach to how to do legal research. And then there are things like just like MidPage is MCP connector, where I was talking to Otto from MidPage last week, and one of the interesting things he mentioned is even though MidPage started as a platform for legal research, now virtually the great percentage of their usage is all coming through Claude, through their MCP connector. People aren't using their platform. They're just, I mean, not at all, but they're using it very little compared to how they're accessing it through Claude. And so I guess what's interesting about all of this, I think, is that we're starting to see, I mean, it used to be legal research was legal research. I mean, there were different providers, but it was basically the same thing, right? I mean, you did use the same set of data, more or less. You approached it the same way, putting in queries and getting lists of cases. Obviously, AI products has changed that in some way, but again, it very much looking alike. Whether you go to Westlaw or Lexis, you put in a question and you get an answer, and you get a list of cases that matches that answer. But it seems like there's this whole trend toward making legal research much more customizable to the particular workflow, to the particular way you like to do research, to the particular applications you work with. And I haven't really put my thoughts together entirely on this, but I think we are kind of, in a sense, on the dawn of a whole new maybe spur in the way legal research products are going to be developing over the next couple of years. So I don't know. Does that make any sense? Anybody think there's anything to that, or?
Yes.
I don't know. Oh, so go ahead, Rhys.
I have some shameless self-promotion. I actually did 2 articles in this, or potentially 3. I cannot remember. It was like in April and May. And it's just kind of like, like around the explosion of like legal research startups and like why we're seeing that explosion right now. And it essentially comes down to 2 issues. One, the tech has improved where somebody can essentially tell like the AI agents to go to all these court websites and just scan everything and to do it in real time, and they can do it cheaply too. I mean, like it's crazy how Describe is like, a very tiny company and it's a husband and wife team, and they were able to do stuff that I was quite impressed with. Like in 2016 when I first came here, like I talked to Case Techs and to Ross too, and like they were the new kids on the block, and it was really hard to acquire all that case law. Like it's really easy these days, due to the tech and also due to the expansion of the free law project as well. I actually talked to Mike Lesnar,
Yeah.
and he has expanded his database a ton, and it actually seems to be like fueling all these new like research tools. And the cat's kind of out of the bag. We have the data, we have the tech, because people can just like plug into Claude, plug into GPT, and essentially say, okay, like, like splice this data up. So like, like all the high barriers to entry have shrunk a ton, and it's shrunk to the point where like almost anyone who has the tech know-how can create their own custom like research tool. Like we are in the second Cambrian explosion, essentially. And I cannot actually say that quote's from me. I talked to uh, Pablo at Case Text, and he, called it the second Cambrian explosion, and he sees the whole industry changing.
Yeah.
I I was I don't know if I may have talked about it here. I wrote an article about Claude Legal, but more broadly, how I think that how I conducted legal research using Claude Legal applied to one of the big two, applied to Mid-Pages database, or no, Claude Legal applied to Mid-Pages database, research in Mid-Page, and then research in one of the big two using their, AI functionality. And the Claude Legal applied to Mid-Page, the results were so much more sophisticated. It was, the analysis was equivalent of someone who litigated for 30 years. It really impressed me. And I also, in the same article, talked about how I'd used Claude Legal and ChatGPT to assist me with all the different hurdles I had to go through to get our, small lot winery here in the Finger Lakes licensed, New York and federally, to go through the trademark process so that I could get an intent to use for our name and make sure that that was cleared, and to go through a whole bunch of other different regulatory things I had to do on the New York side of this. But, I wasn't a transactional, I was a litigator, so all of this was new to me. I did watch a CLE, by the way. Alt Legal had a CLE specific to wine and trademark, so I did watch that to really give me like the foundational information I needed for that. But I was able to get all of those things done quickly without a lot of back and forth, which I think, from what I've understood, it can be kind of typical. It helped me answer all the questions correctly on the forums, and the research when you take a matter that's designed for, not a matter, but a model designed for legal and apply it to a reliable legal database, the output is unbelievable, and it's far exceeded the output from either of those LLMs applied to their data, companies, guardrailed and everything else LLMs that they had applied to their databases. So I think 100% that the trend is going to be exactly what you were both talking about, is sort of this customizable ability to do research, but also I think the top is going to be one of these models tailored for legal applied to one of the many different case law and regulatory databases. So we'll see, but you can get a lot done with them.
So the question is, I guess, like, like how do the huge players like Clio and TR and Lexis essentially respond? And I spoke to TR2 for the article, and they were just, like all about like how the editorial expertise they have is going to keep them ahead of everybody else, how they are like the only trusted source, and that, like there's some truth to it too, and like how they're, like complex like secondary treaties too are really hard to replicate. And also like how they're, really going full on with like creating their own AI. Like it's crazy. It's essentially become like a race, and it's completely changed from a pretty stable, market where you essentially had like two or three giant players who controlled everything. It's completely like turned on its head.
Yeah, and you talk about, I forget what he said, Pablo said this is the second, I forget what he said, but there was in fact an earlier kind of surge, in the, like around 20, what was it? Andrew can tell us when, I think it was 2014 that Ross got launched, Casetext launched around the same time, Ravel launched around the same time. And those were all, again, sort of attempts to take very different approaches to legal research. But I think Rhys and Niki both kind of hit the nail on the head in terms of talking about how the technology now makes it so much easier to do this, and not just to try and do some more or less slight variation on what Westlaw and Lexis are doing, but to really be different in your approach to how you build these products. So it really is it's a really interesting time, I think, for the field. And it's funny because I've just over the years of watching legal tech, it's one of those topics that has sort of come up in waves. It's like for years nothing new happens in legal research, and then there will be this surge of a bunch of new products, and then nothing new will happen again for a while, or nothing major. But we're certainly in one of those times right now.
So should we all start our own legal research companies and wineries?
I think, yeah, definitely wineries, but I think we also just need to create some AI tools. We keep talking about this. We just have to do it. Our multi-million-dollar payout is right around the corner, and that can help fund my winery, by the way. So I'm all in. I'm all in for this. We're looking for investors, sort of, not really, but I'm all in on this. Let's start. Let's go. It may as well be a research tool. So let's do an AI research tool, you guys. We'll work on it at Delta.
Yeah.
Well, but I don't know that we should be all starting this, because I think really the real threat, and we've talked about this a million times, isn't all these myriad little startups that are coming along and building MCP connectors or something. The real threat is that company that they're all building the connectors based on. I mean, it's Anthropic, it's OpenAI. When you talk about asking Westlaw or Thomson Reuters whether they see this as a threat, to me, that and we've talked about this a million times, but it's the general models that are the threat here, and and that extends to almost all of legal tech. I mean, it's really getting to the point where there isn't anything you can build on just on Claude that you would need a separate platform for. I hate to say it, but.
I just feel like, well, and this is what I thought about the Described news earlier when I heard it too, and I also haven't had a chance to write about it, but there is something to be said for those big, like we were talking about the open weight models and everything. The downside of those big folks who can come in and, do a lot in this industry, but they also don't give somebody the kind of power to create their bespoke version of what they want to do nearly as well. And that's why, like when I was talking with Describe about what they're doing, I kind of liken it more as the analogy I came away with was more like an IKEA situation where you say, I'm not going to try to sell furniture at this point because everybody, whatever, but I've already done the work of building designs, and you can put together what you need to do on top of this. But I'm going to start basically selling the fact that I've come up with a better, done the legwork on the design. And I think there is something to that might be the intermediary, because I think we kind of have talked about the idea of like a Claude or OpenAI out of a box jumping into legal, but I think we're going to see them stumble just over the fact that all legal is slightly different. But if you can be in between and give something that allows folks to build what they need with a little bit of technical stuff already done, like that might be a strong place to be, because I think everybody's going to want to have some degree of control over what their AI looks like in the near future, which goes back to the Chinese model situation.
Yeah, 100% agree with that. Yeah, that makes sense. All right. Anything else we forgot to talk about?
Thompson created a new large language model called Thompson. Surprise, surprise.
Yeah, we've talked about that before, but they
Yeah.
came out with new information on it. Yeah.
Yeah, they like did come out with like new benchmarks, and surprise, surprise, it does pretty well. And they also say they spent around 20 million creating it, which was interesting. It just, gives people a sense of how, like, like the cost of, creating your own large language model. And just, going to the earlier point too, like they are really, like trying to win the AI race too, and they're spending tons of their own cash due to the fact of like all these new startups kind of like trying to like take over this space. They're really like trying to like hone in on we are the most trustworthy and accurate too. Um, and it's kind of hard because it ties to in a whole other conversation about like how these tools hallucinate as well, and how that's a feature for like all of them. Except that's probably a conversation for some other time because I think we're almost at time, and that will open up a can of worms.
Yeah. Yeah, they're leaning big into that trust trust issue as their moat, so to speak. All right, yeah, no, look, no bar exam. We didn't even talk about bar exams. Jeez.
Oh,
I mean, that was a lot of my week. But not so much legal techie, but it was a lot of my week for other reasons. But
Yeah, yeah. All right. Well, maybe we can catch up on that another time. All right. Well, I think that does it for today's show, and I hope everybody has a great week, and hope to see you all back here next week.
bye, everyone.
Yeah.